Hello everyone and welcome to this video on legal systems. We're going to be looking at what legal systems are, the different range of legal systems in place around the world in different countries, and then lastly we're going to take a quick look at intellectual property, which is massively impacted by the legal system of the country and of particular interest to many international businesses. So if we start with the question of what legal systems actually are, well, they're everything from the institutions that create law, so that will be usually legislative bodies or governing systems, to the bodies that interpret law, which would typically be courts, as well as other means of interpretation and application, down to the enforcement of laws within a state. So that would be police systems and other law enforcement mechanisms. So essentially, the mechanisms to create, interpret, and enforce laws would be collectively termed a legal system. Now, before we go on and look at exactly what different types of legal systems are in existence, we do have to make a distinction between the rule of law and the rule of man. So this is just looking at how law is actually practically applied, not just the legal system as it exists in theory or on paper within any given state. So the rule of law would be the type of legal system which predominantly consists of systematic laws applied by public officials who are held accountable for their administration. So here, law would apply to any individual within the state, and the application is systematic. It does not take into consideration who that individual is. So in a country which predominantly has the rule of law, whether you're a member of the ruling classes, whether you're a member, a disenfranchised member of society, or relatively poor, whether you have a relation or a connection to the president or prime minister, all of this is irrelevant. The law will be applied to your actions in a systematic manner. To contrast to this, the rule of man will be the type of implementation of a body of law which depends really upon the individual and their power to influence the imposition of law. So the legal rights really and the imposition of legal rights can be understood to be derived from individuals rather than the systematic application of law. So if you're someone who has a close personal connection to those in positions of power, law may well be applied in a different manner to you. Now, this is just a contrast looking very much at the practical application of law. It's fair to say that in all countries there is a wavering between these two extremes. Law is systematically applied in most cases in many countries, but there may be some exceptions. And rule of man may generally apply in other countries, but there will again be exceptions depending on power, interest, and circumstance. So it's just really a reminder that law as it exists on paper doesn't necessarily constitute the legal environment. The application of law will differ widely from country to country, and it may well swing between the systematic application of law, which is the rule of law, versus the selective and individual influence-based imposition of law, which is the rule of man. With that said, we can go on and look at the four major groups or types of legal systems in existence. So this is civil law, common law, customary law, and theocratic law. As well as defining each, we're going to look at, generally speaking, where these legal systems apply in the world today. So if we start with the first, a civil law system, This is a legal system where laws and regulations are passed by a legislative body, and all law is codified and written down. So under a civil law system, if you want to understand which laws apply to you and how they apply, you're generally looking at acts or bills passed by a parliament or a congress or some kind of legislative body. In many democratic systems, this will be an elected chamber, but isn't necessarily have to be elected. It just has to be a recognized legislative body of the country which passes law. Because law is codified under a civil law system, judges and courts have limited ability to interpret law. They generally have to apply law as it's written. And again, all law is codified and written. So if we look at a map of the world and see where legal systems are implemented, we see that civil law is by far the dominant legal system in the world today. The majority of states in the world have a form of civil law system. We're just going to take a few minutes here to recognize that there are a massive range of colors on this map. And that's because many countries today, because of various quirks of history, actually have a mixed system of law. So if we zoom a little bit closer at the bottom here at the legend, we can see that there are 4 groups of law. So we have civil law, common law, customary law, and then we have the 2 dominant forms of theocratic law, which is to say Muslim and Jewish law, or Sharia and Halakha. But the actual existence of legal systems and the different types of legal systems in the vast majority of cases tend to be various mixed systems. That may be because certain provinces or regions within that state have different legal systems. So there may be federal law as well as state law or regional law, or it may be that different categories of law derive from different types of legal systems. So criminal law may be civil law, but personal law relating to status law, such as things like marriages and divorces and family law, may be based on customary law or theocratic law. So lots and lots of countries in the world today have mixed law systems. But if you look at the map, the countries which are predominantly blue, either a darker or a lighter shade of blue, are based on civil law systems of some description. Now, civil law is closely associated with France, and you will see the majority of French colonial or former French colonies having some form of civil law system, as well as practically, with the exception of the UK, practically the whole of Europe, as well as the vast majority of South America and Central America, as well as significant parts of Africa and Asia, being based on a civil law system. So these are legal systems where law is codified, written down, and passed by a legislative body, and there's limited ability for judges and courts to interpret. This is generally quite favorable for international businesses or businesses of any description, notwithstanding the reality of the difference between the rule of law and the rule of man, of course. Because law is codified and written, there is a high degree of certainty as to what the law actually is and how it's going to be interpreted. So businesses will generally adapt to any kind of legal system as long as there is certainty. Where there's uncertainty, where businesses are not sure exactly what the law is, or they're not sure how the law is going to be interpreted and applied, that creates uncertainty, and that's something which businesses very much want to avoid. So as long as there is a systematic application of law, civil law systems really do provide a very high degree of certainty. So if we move on to our second major type of legal system, we have common law. Now, common law is broadly the same as civil law in that they tend to be a legislative body which passes written laws which are codified. Common law systems also add to this interpretation and judgments made by individual judges. So this means that the function of judges and courts is not just to narrowly apply the law as written, but they can actually also pass rulings which establish precedent. So an example of this would be in the UK. For a long time, there was no act of parliament which actually prohibited murder or defined murder as a crime. This didn't mean that because there was no act of parliament or written law which prohibited murder, it was legal to go around murdering people in the UK. It was just that there was a ruling in the far distant past where a judge actually convicted someone of murder, and this established a precedent. So the source of murder for a long time, the source of the law against murder for a long time, was not actually based on an act of parliament, but rather based upon judicial precedent. So under common law systems, there is greater scope for a judge or a court to actually establish binding precedent. So future cases heard by other judges and other courts would follow that binding precedent and also effectively create law through the court system. So if we look at the common law system in use around the world today, well, the thing that should stand out, so this is broadly the countries in pink or red. And the thing that should stand out to us is that this broadly does include mostly the Anglosphere. So Britain, the UK as a whole, with the exception of Scotland, which actually does have a mixed system of common and civil law, but the UK in general is a long established common law legal system. And if we look at the English speaking colonies, which are called the Anglosphere, so New Zealand, the United States of America, Canada and Australia, also follow the common law system, and you also have many mixed systems with elements of common law in many former British colonies. So we can really see that legal systems are the use of legal systems are historic. They're based upon the historical context of that particular country, and in these cases very much the colonial context. So former British colonies have a much higher chance of having a common law system, as well as a governance system based on the parliamentary system, because of the influence of the colonial period and in many cases the inheritance of English common law. So if you look at as an example in Pakistan, the legal system still today operates for criminal matters as well as some civil matters in the English language, because English common law is still a valid source of law in Pakistan, and the judicial precedents and court rulings in the past in English common law are written in English. So as a result, courts in Pakistan will actually operate using the English language, again literally inheriting that body of common law from the British Empire even after independence. Now, there would be a slight theoretical preference for civil law amongst international businesses, because common law does actually add this increased role for courts and judges in interpreting law and in some cases actually creating law. So if we return to our kind of guiding principle, that international businesses need certainty, they need predictability, they need to base their decisions on a strong understanding of what actually is legal, what isn't legal, and how the law is going to be interpreted and applied. So common law systems in theory have greater freedom for judges to apply their own reasoning, to apply their own interpretation, but this is a slight theoretical preference. In reality, common law systems do not allow judges to establish binding precedent when it directly contradicts with a law or an act of parliament or an act of the judicial body. So you won't get a law which is on the as part of codified law passed by a legislative body, which is then directly contradicted by the rulings of a judge. Instead, judicial precedent is established where there is some amount of ambiguity or uncertainty, and judicial precedent is then binding. So that actually removes, so that the fact that a judge makes a particular ruling and establishes a precedent actually removes that ambiguity from the future, because then it's quite clear that that judicial precedent is binding, and therefore there is certainty on how future judges are going to apply law in that particular circumstance. So while there is a slight theoretical preference for civil law systems, in general, both civil and common law systems represent fairly predictable systems of law, that any organization or individual operating within that state has a reasonable certainty as to what the law is, what is legal, what isn't legal, and how law is going to be applied and and interpreted. Again, I keep saying this. This is presuming that there is a fairly reasonable application of the rule of law, i.e. the systematic application of law. If you have a strong tradition or a application of the rule of man, then really there is no permanent certainty, there's no real certainty, because the rule of man is not systematic application of law. So whatever the legal system, the actual application of law is highly individualized and depends on context, relationships, and circumstance. So that's civil and common law. If we move from that to our other two bodies of law, there is far more uncertainty with both customary law and theocratic law. So if we tackle customary law first, this is a legal system where law is derived not from a legislative body, so not from a congress or a parliament, but rather law is derived from the historic custom and practice of the community where that law applies. So if you have a community where certain acts have always been prohibited, you don't need to have a written law, you don't need to have an act or a bill passed by parliament. It will be illegal because it's the demonstrated custom and practice for hundreds or even thousands of years, and therefore it is part of customary law. So this is not law which is necessarily written down. This is not law which is passed by some kind of legislative body, but rather this is law which exists because it is part of the custom of the community or the people where that law applies. If we look at where customary law actually applies, we see that customary law here, countries are predominantly customary law systems will be in varying shades of yellow or orange. That there, India is a notable legal system, a state where the legal system is in part and in geographical region based on customary law, but we also have significant parts of Africa, both West Africa and Southern and Central Africa, which have legal systems which are in part apply customary law, as well as another noteworthy country would be Malaysia. A good example of this would be Nigeria. So if we just zoom in and focus on Nigeria for a moment, Nigeria has a mixed legal system, but we can see that certain parts of the country, so this isn't the entire country of Nigeria, but rather certain regions where customary law is actually a valid source of law. So you may ask that, is this really certain? Does this give a degree of certain and predictability? And the answer, frankly, is no. So if you look at the custom and practice of any people, there will be legends and myths that this is always the way things have been done, but that often is not true. The custom and practice of peoples is not fixed in time. Almost all peoples and communities have some sort of founding or originating myth. Many peoples and communities and even proto-nations and ethnic groups would like to believe that they have always existed throughout history. So the English would like to believe there's always been an English people, and English customs go back thousands and thousands of years. This generally is not true. The custom and practice of a people evolves over time and is often used for particular purposes. So it would be very dangerous to assume that customary law, based upon the customs of a people, is genuinely long-standing. In many cases, it is not long-standing. In many other cases, custom is disputed, whether a particular custom is genuinely part of the heritage of a particular community. These are very, very controversial issues depending on circumstance, and certainty is quite difficult to get. The reason why Nigeria is an interesting example, if we look at how customary law actually applies in Nigeria, we see that it's quite loose. So a legal case can be brought based upon customary law, but the onus for demonstrating that a particular custom is part of the custom and practice of that particular region is placed upon the burden of proof is placed upon the person who brings forward that legal case. And they can do so by invoking evidence based upon demonstrated recorded practice. They can use judicial precedent by citing Nigerian legal records and judicial notices. But this is a matter of real broad interpretation, argument, and therefore it's very difficult to systematically apply customary law, simply because customary law does not exist in a systematic codified form. So if law is not codified, that makes it extremely difficult to be systematically and predictably applied. So there is certainly a major concern around how predictable and how certain operating under customary law jurisdictions actually is. If we just move to our last of the four major types of legal system, we have theocratic law. Theocratic law can be quite commonly misunderstood. So theocratic law essentially is law based upon some kind of religious text, so a religious holy book of some description. And we saw from the map earlier that the two major types of theocratic law in existence are Muslim law and Jewish law, or Sharia law and Halakha law. Now, the reason why theocratic law is often misunderstood is firstly, if we look at the sweep of theocratic law systems in existence today, we see quite a wide range of countries in varying shades of green, which would relate to Muslim law or Sharia law systems. And there's an assumption that this is uniform, so there is one single thing called Sharia law, and it is applied in a systematic manner across all civil and criminal cases. The problem with this understanding of theocratic law is, firstly, it's just not true. Law as it's applied in, let's say, Morocco is vastly different than law as it's applied in, say, Afghanistan or Pakistan or Iran. Huge practical and textual differences. And the second reason is that not only is this not true, it cannot be true, because religious holy texts, particularly in the case of the three Abrahamic religions, Judaism, Christianity and Islam, are not books of law. So if you look at the Quran, for example, it's like the Bible, the New Testament and the Torah and the Old Testament are not, the Quran is not a book of law. Less than 5% of the Quran actually deals with anything relating to legal matters. It, like the Bible, like the Torah, is a book of poetry. Now, the one thing that you should be aware of is that poetry is a very poor type of writing to base a legal system upon. Poetry serves many functions, religious philosophy serves many functions, but legal writing is very detailed and dry, is very distinctive, because we need to make sure we have minimum room for interpretation when it comes to legal writing. So if you take a book of poetry and try to base a legal system on it, it's a huge amount of your interpretation rather than anything which is directly and unambiguously contained within the text. So two countries which both have, say, Sharia law systems or theocratic law systems based on the Quran can come to very, very different understandings and interpretations of the law. The same thing very much applies to Jewish law or halakha as well. And in fact, there was a recent controversy in Israel where Jewish law is applied to particularly personal law, but also has some pretty important ramifications with regards to eligibility for citizenship, where Ugandan Jews, so East African Jews, were determined to not fulfill the criteria of actually being recognizably Jewish, so therefore are not eligible for citizenship, are not eligible for various privileges and rights within the state of Israel. And that's quite fiercely contested. So it's very easy to say, well, it's law based upon a religious text, but we have to remember that religious texts are, for the most part, within the Abrahamic tradition, certainly, so Islam, Judaism, and Christianity are books of poetry, are not books of law, so they make very poor sources for a systematic body of laws. The other reason that we should be quite cautious when people talk about Sharia as if it's a monolithic entity is that even if we take the body of judicial interpretation which has sprung up over the centuries around Sharia law or Muslim law, it was not designed or interpreted in a systematic fashion. It was a very, very different legal tradition where differing interpretations, differing rulings all comfortably coexisted alongside of each other, and there was a far more decentralized, distributed network of justice and legal application. So if we take this long tradition of Sharia law, which is a very diverse and is a tradition rather than a history of a single body of law, and try and apply it to a legal system like a modern legal system which requires clarity, uniformity, and codification, it's a very, very messy situation, and we see this in how Sharia is practically implemented. The majority of countries have elements of Sharia for aspects of personal law. So if you look at the North African Maghreb, so the countries along the north coast of Africa, they largely reserve Sharia law for things relating to marriages, inheritance, and personal and status law, rather than either business law or criminal law. Those countries where Sharia is normally the law of the land, which includes criminal law. So if we take Saudi Arabia, which normally has the Quran and Sharia law as the basis of the entire legal system, there is huge variations and differences in interpretation. So Saudi Arabia is the only Muslim country to regard women as driving as being illegal and against the Sharia tradition, whereas the every single other interpretation of Sharia seems to have no problem with women driving. The fact that this has changed recently has got less to do with the theocratic underpinnings of Saudi system and more to do with power balances within the country, the rise of Mohammed bin Salman, and the change of political leadership. So it's very difficult to get a systematic application of law through theocratic law, again because religious texts are not legal texts. They're books of poetry and books of religious insight and spirituality, rather than being sources of systematic application of law. Lots and lots of myths around Jewish law and Sharia law. It's worth just taking a moment to kind of recognize that the reality is often more complex and also very different from the common understandings of Sharia law being some kind of monolithic block of law. Sorry, just to go back there for a second, it's worth kind of stating, although it should be fairly obvious, that when it comes to international businesses, theocratic law is not an ideal situation. Companies that engage in Saudi Arabia, for example, do not do so because of certainty that theocratic law is going to be understood and interpreted in a uniform, systematic fashion, but because of their belief in Saudi's political stability and therefore the rule of man which very much does exist in Saudi and is quite evident in even modern and current events happening within the country, that provides companies with a degree of certainty because of their own contacts, their own position, their own role, rather than the fact that there is a legal system that will be cleanly and consistently interpreted and applied in the same way. So these two legal systems, both customary and theocratic legal systems, are in many fundamental ways very different from civil and common law systems, and the degree of certainty and the degree of predictability tends to be either much lower than civil or common law systems, or tends to be based upon something different. So the certainty is because of the certainty engendered by the stability of the regime and the predictability of the regime's interests, rather than that of an independent legal system or an independent judiciary systematically applying a predictable set of laws. Right, so we've covered the four major legal systems in the world today. So civil law, common law, customary law, and theocratic law. We're just going to very quickly take a look at intellectual property, because intellectual property, defined as non-tangible property, so something of value, something which can belong to someone or arguably belong to someone, but isn't physical, isn't tangible, is intellectual or non-tangible. This kind of property very much depends on the predictable application of laws to be protected. So whereas steps can often be taken to protect physical property, intellectual property almost entirely depends upon the application of laws in a systemic fashion to be protected. So we are going to go on and look at this in more detail later on in the course, but for now what we just want to do is take a look at what the four major types of intellectual property are, and in which ways they need to be protected by legal systems. So if we start with patents, now you may have the idea that patents are ideas which belong to someone. That isn't the case. You cannot protect an idea. I can have an idea right now about a flying car or a pen that both writes and makes pizza, but this is a idea that has no value unless there is a particular method or invention which brings it into reality. So what a patent is, patent is a particular invention or process or method for doing something which belongs to or originated from someone, and what a patent system does is gives protection to the inventor to only profit from their invention within a certain time frame, as long as that invention is published. So patents have to be published, they have to be detailed, so it adds to the body of public knowledge. So there is a public good justification for patents, but in exchange the state or the patent system will protect that particular invention or process or method for a fixed period, often 20 years and in some cases longer. So if you have an international business which depends on patented technology, it really needs the countries that it operates in to protect that patented technology. Otherwise, it's at risk of competitors taking those patents and using them without permission, without fees, and without compensation. Trademarks are slightly different. Trademarks are not inventions, but they are simply some kind of distinctive design, symbol, or name which identifies a particular product, service, or company. So McDonald's is a patent, but anything which serves as a unique identifier can also, McDonald's is a trademark, but anything which identifies a unique product, service, or company can be a trademark as well. So as well as the name McDonald's, the logo of McDonald's, the so-called golden arches, the giant golden M, is also a trademark. but also even the "I'm loving it" slogan and sung in that particular tune. So that arrangement of notes, that musical kind of motif, is also trademarked because it is closely associated with and serves to identify McDonald's as a brand, as well as an array of products and services. So the McSandwich or the Big Mac are again trademarks. There's a lot of interesting justification for trademarks, and lots of particular areas where they apply and where they don't apply. So a trademark has to be real. It has to actively serve to identify products, services, or a brand. It cannot be potential in the future. So we see that Apple, despite having trademarks on things like the iPhone, the iPad, the iMac, and so on, iPlayer is owned by the BBC, because at the time that the iPlayer service by the BBC was launched, Apple were not active in the online video streaming market. So Apple did try and challenge this, but they were slapped down because there has to be an actual public good justification for trademarks, and that is that it prevents companies from tricking customers into thinking they're dealing with a particular company when they're not, or tricking customers into thinking they're buying a particular product when they're buying a different product made by a different company. So there has to be a public good justification for trademarks also. The third category of intellectual property, which is protected by law, or by most laws in most legal jurisdictions and legal systems, is copyright. Now, copyright doesn't deal with either inventions or identifying distinctive marks. Instead, copyright deals with artistic works. So copyright protects authors and gives the right of authors to exclusively profit and sell their distinctive works, which include things like music, books, movies, paintings, software. So any kind of creative work can actually be copyrighted. It doesn't enshrine the rights of being identified as the author. That's a natural right. So even if books are out of copyright, the author has a right to be identified as the author of that particular work. But instead, copyright allows for the author and the holder of copyright. So authors can actually sell copyright, the rights of copyright to their work to third parties, but it protects their rights to actually profit and use those particular artistic works. So you're unable to just take a movie that you've seen in the cinema and make a video recording and then sell that video recording, or even distribute it, because that movie would be under copyright. So the right of the authors to control their artistic work is enshrined. Copyright, again, is based upon an argument of public good. It's not something which states, legal systems, and courts are protecting for no reason. It's essentially to encourage the creation of creative works. So by protecting the right of, let's say, an author of a book to actually control and profit from their book, society is encouraging more people to create more books. To protect the right of a musician to control their own artistic product, i.e. music, they're encouraging more people to create music. So because there is a clear public good in this, copyright tends to be restricted, is not eternal. So music, for example, I think is 50 years, although that may be wrong. You may want to look that up. As well as other types of copyright in the UK tend to be the life of the author plus 20 years, or the life of the author plus 30 years. So there is a limitation on copyright. It doesn't last for forever. It doesn't last for centuries and centuries, because there is a stated public good, which is the encouragement for the creation of more artistic works. Now, those three types of intellectual property, patents, trademarks, and copyrights, are all protected by legal systems. By and large, the legal systems which take intellectual property seriously, which is not all of them. but they also require public disclosure. So patents protect an invention or a method, but that has to be publicly published. So anyone can go to the patent office website in the EU, for example, and actually look through designs and inventions and patents. You're not legally able to use them, and if you do, you'll be sued and end up owing a lot of money. But you can actually look at the knowledge behind those patents. Similarly, trademarks have to be public, otherwise they wouldn't be protecting anything valuable, and copyright applies to published works rather than private works. The difference between those three and trade secrets is that trade secrets is a form of intellectual property where there is no public legal protection. So you can have a trade secret, and there are many. So for example, the Coca-Cola formula is a trade secret. The was it 11 herbs and spices blend for KFC is a trade secret. But these have not been patented or have not been copyrighted either. So therefore there is no protection. Now, if you try and break in to KFC's offices and get hold of the actual recipe, you're breaking and entering, you're breaking another law. But if you were to get hold of it and publish it, you would be punished for the break-in, but people could freely distribute and exchange the recipe without any legal repercussions. So if you keep your intellectual property as a trade secret, you don't have to publish this. It doesn't have to be in the public domain. However, then you also lose the ability to use courts to protect your intellectual property.